Hello, my name is Joanna Connolly and I'm a solicitor advocate. I'd like to thank you for joining me in this MBL seminar on consumer credit legislation under English law. I have a law practice based in Frodsham, Cheshire, but have been specialising in consumer credit regulation and FCA authorised consumer finance matters for the last 18 years. Consumer credit is one of the most highly regulated areas of law, and consequently I appear in courts throughout England and Wales, mainly defending debt claims relating to CCA regulated agreements. Today I'd like to give you an overview of the regulatory framework as consumer credit affects us all in one way or another. From a personal point of view, you may have a mortgage or a vehicle on finance or a lease deal. You might buy a large item on a buy now, pay later scheme. This regulatory framework applies to all of those. In your professional life, you may come across consumer credit in many ways. Your company may offer some form of deferred payment options, in which case you need to be sure you're operating within the CCA and regulations, or perhaps within the exemptions. A land registry transaction may be held up due to an unexpected second charge on a property for a CCA debt. This is a common occurrence. A client could have a car seized by the police and find that the loan or lease company repossess it immediately. A will or probate case will often unearth old consumer credit debts for credit cards and personal loans, or a client may come to you with a complaint against a utility bill getting rails wrong. These are all issues involving consumer credit law and regulations, and consumer law generally. If you're new to this area, don't worry. We'll start with basics and build up, explaining key terms as we go. I'll define jargon on first use. For example, APR means annual percentage rate, the total cost of borrowing expressed as a yearly percentage, and includes some why it matters tips for practical advice. All references I use are current as of 29th of October 25. Consumer credit law exists to protect people or consumers borrowing money or buying on credits such as credit cards and personal loans from unfair practices while ensuring that lenders follow rules. If a lender breaks the rules, agreements can become unenforceable, which means courts won't make borrowers repay the capital or pay interest and fees during the period the creditor is in breach. And if the credit agreement predates 6th of April 2007, irredeemably unenforceability under Section 1273 of the Consumer Credit Act, CCA, still applies.